Good morning, everybody. In the previous video, we discussed Article 177, which related to the right of the ministers and Advocate General to participate in the proceedings of the legislatures and to speak in them. In this video, let us discuss Article 178, 179, 180, and 181 relating to the Speaker and Deputy Speaker of state legislatures. Article 178 says that the Legislative Assembly shall choose a Speaker and a Deputy Speaker. By this you must understand who will become Speaker and Deputy Speaker. The State Legislative Assembly is choosing. So the Speaker and Deputy Speaker invariably belong to the party which has majority in the Assembly. In terms of Article 179, the Speaker or the Deputy Speaker lose their jobs in three ways. Number one, if they cease to be member of that house. You know, when one ceases to be member of that house, if he acquires any disqualifications, he ceases to be member of that house. Number two is he may resign. Speaker may resign by giving his resignation letter to the Deputy Speaker, and the Deputy Speaker may resign by giving his resignation letter to the Speaker. And the third is removing them by the Assembly by a resolution. Article 181 says that the Speaker shall not preside over the proceedings when his own removal was being discussed in the Assembly. We know the functions of the Speaker is to regulate the proceedings of the House, and that he will not do while a discussion about his removal was being discussed in the Houses. This is everything as regards as the plain language of Articles 178, 179, 180 and 181 is concerned. But the controversial issue is under Schedule 10, which was created through 52nd Constitutional Amendment of 1985, prescribing disqualifications for the members who defect from one party to the other. It is called anti-defection law. We know if any person defects from one party to the other, he loses his membership of the legislatures, with an exception that if 1/3 of a political party leaves that party and joins another party, defects to another party, they will not be disqualified. As a result, this anti-defection law worked as wholesale defection encouragement bill. Instead of going singly, they will think of going in groups of at least 1/3 each. That would be fatal. That may result in dissolution of the government, dissolution of houses midterm, and going for midterm elections, which is an unnecessary affair and done without constitutional knowledge. Under this anti-defection bill, the power to decide the disqualification was given to the Speaker of that state. This is what I object to, because it is the right of the governor under Article 192 to decide the qualification of members. Why this power of the governor should be removed from him and given to the Speaker? Speaker is, after all, a person belonging to a particular party, especially to one which has majority in the House. He will invite people, whoever want to come to his political party, and whoever wants to go away from his party, he will take decisions sooner and disqualify that person. There have been cases when the issue of disqualification was not cleared by the speakers until the closure of terms of the legislatures. And further it is said that it is deemed to be a legislative proceedings under Article 212 and the judiciary cannot interfere with it. Third is that the Speaker himself is liable under the anti-defection law. So he is a party elected man, he himself is liable under the anti-defection law. How can the power of deciding the disqualification can be entrusted to us? He will act with bias. So that is what is happening. The Honorable Supreme Court was compelled to direct the Speaker to take a decision within 3 months. It was a shame on the part of Indian polity And of course, this was the flaw in drafting the anti-defection bill. If it is the governor, he doesn't bother who comes into his party and who goes out of his party, because he is an executive and his authority is not fettered by the strength of his party in the assembly. Majority has nothing to do with formation of government in a state or the union level. That should be the real democracy. This way, by misusing, misunderstanding, misinterpreting the constitution, we have destroyed Indian democracy and Indian constitution. We are not able to derive the benefit of such a largest constitution in the world, written by none other than Dr. B.R. Ambedkar. Undoubtedly, Indian constitution is not only the largest written constitution in the world, it is also one of the best constitution in the world. What is not in Indian constitution is not there outside. It is time for the people of India, polity, president, judiciary and intelligentsia to understand the true purport of the constitution and force its implementation. Otherwise, the country is going to suffer a lot. It may lead to disintegration of this country or to losing of independence in future. There will be social, political, economic turmoil in this country if the present system is continued. Thank you for watching my videos. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. And if you provide your telephone number in the comment box, I may even call you in person. The very purpose of starting this web series is to bring to the notice of the Indian citizens the true purport of Indian Constitution in the 75th year of its implementation. I have dedicated my life to read the Constitution intently, and I have written 2 books on it. One is Indian Politics versus Indian Constitution in English, and the other is Bharata Prajalamagu Memo in Telugu. It is also, of course, translated into Hindi. These books are available online on Amazon, Flipkart, Kobo, and at Notion Press. I request you to please read the books. You will have all the topics in them. Once again, thank you for watching my video.